Thank you. We will return with the Integrity and Security Group, and we'll return with Senator Cash.
Thank you. If I could just turn to a series of questions in relation to the return of the ISIS brides, both the cohort that have recently arrived but also the cohort that media are reporting are due to touch down potentially tomorrow. Just in terms of the Attorney-General's role, on what date was the Attorney-General first formally briefed on the planned 7 May 2026 return of the 4 women and 9 children from El Roj?
We'll have to take that on notice.
Could you give me any form of indication as to, are we talking 2025, 2026? So I've established that the Attorney-General was written to by the CDPP on the 20th of November in relation to consent to prosecute. That consent to prosecute was given on the 15th of December, and that's in relation to this particular cohort. So can I get any guidance at all in terms of a briefing to the Attorney-General on their planned return?
We'll need to take that on notice.
Okay. Who would have given the briefing? The Department, ASIO, the AFP, the Counter-Terrorism Coordinator, the National Security Advisor, the Home Affairs Minister, the Prime Minister?
I mean, we provide advice to the Attorney-General, including when there are any national security of cabinet discussions, but we need to take on notice anything more than that.
Okay. Can you take on notice then whether the briefing was oral or written, on what date did the briefing occur, etc.?
Yes.
This is in relation to the 7 May cohort. Did the Attorney-General receive any informal advice or formal advice or warning about this cohort's intended return prior to any formal briefings? So in terms of there's formal briefings, but then there's also informal discussions?
We'll have to take that on notice.
Can I also get you then to take on notice when the September 2025 cohort returned, on what date was the Attorney-General first briefed about that return as well?
Yes.
Home Affairs has confirmed it knew of the September 2025 return plans from June 2025. So whether or not also the Attorney-General knew from June 2025 as well. In relation to the current cohort that are apparently en route to Australia, what level of knowledge does the department have in relation to this cohort?
I think both, I mean, there's sort of changes in their circumstances that happen over time.
So what does that mean?
So it would just mean that at any point what is happening with them has moved, I guess. So
what is happening with them?
With those who remain in Syria has,
yes,
changed. Obviously they've moved, returned to camps, etc. So do
you know how many are coming back to Australia?
I think we have some awareness of that. I'll ask Mr Moffat if
I don't have those numbers on hand.
Is it 5? Is it 10? Is it 15? Is it 20? You must have some general idea. This is one of the most significant events that Australians are currently watching in anticipation, the touchdown of more ISIS brides.
I think when we talk about awareness of it, I think it's important to contextualise it, and these individuals have expressed for a period of time a desire to come home. The department has been aware of that. In terms of then the various steps in between, it is not. There is various reporting along the way about different different intentions and possibilities, but that does not go to knowledge of actual movement. At the moment, there's reporting about a group. I don't recall the precise number of the group in total, except there is a number of adults and accompanying children in that group.
Okay. Secretary, have you got any awareness as to how many of the next group of ISIS brides coming to Australia are actually coming? How big the group is?
No, Senator, I don't. I have nothing further to add than what Mr Muffet said.
Are you advised as to when they are expected to touch down?
No, Senator.
Is anyone at the table advised as to when they are expected to touch down?
I think we'll have to take that on notice.
Why would you need to take it on notice? You all look at each other like, should we or shouldn't we answer this question? We can FOI all of this. We can do all sorts of things. It's easy just to say here and now, do you know when these people are touching down?
We have some information from operational agencies, but wouldn't want to say anything without checking with them.
So what are the operational agencies that you would have some information on? Because they are going to be appearing at estimates and we can put a whole lot of questions to them about what they've told you.
I think it would be for Home Affairs tomorrow.
Home Affairs. And which particular part of Home Affairs will I be directing the questions as to what they've told the Attorney-General's Department that the Attorney-General's Department was unable to tell me tonight?
So to be the National Security Group?
Yeah, and there's the new counter-terrorism coordinator.
The National Security Group, the new counter-terrorism coordinator. Is that the person?
Yep.
What role does the counter-terrorism coordinator have in all of this?
Well, I think as the name suggests, they play a coordination role across not just the Home Affairs portfolio, but more broadly, so with the national intelligence community agencies like ASD and other entities, ASIO's in the Home Affairs portfolio, so coordinate effort across the national security.
Why would a counter-terrorism coordinator be involved with the return of these women?
I think just broadly, and they may be playing a role. I think probably the oversight is more a matter of the Deputy Secretary, and I'm not sure I've got the exact name of the group right, Senator, but I think it's the National Security Group in the Department of Home Affairs.
Or is it because they're potential terrorists, as the name suggests?
Well, I think the coordinator plays a role engaging with states and territories, so I think it's a mechanism.
Or when the potential terrorists touch down?
I don't know enough to be able to.
Oh, well, I can tell you, I could easily answer this question. These women left Australia to join a death cult. They've associated with terrorists. They married terrorists. They've actually killed people. Some of them have even been charged with crimes against humanity. Good God help us. And no one here seems to know anything about this cohort coming back.
Well, we are not involved in operational oversight or decision making. I think we've given evidence to this committee over recent years to note that probably over the last 7 or 8 years we've provided international law advice as relates to Australians returning from that conflict zone, but we do not have operational responsibilities into these cohorts.
Has the Attorney-General of the Department provided any advice to the Home Affairs Minister, the Prime Minister or the NSC on the management of this cohort's return?
Other than the broad international law advice that I referenced that we've been providing over the last 6 or 7 years, no.
What exactly then is the Attorney-General Department's role in the return of the ISIS brides, or the cohorts that are referred to as ISIS brides and their children?
So we have no direct role, Senator.
Okay, no direct role. What's your indirect role?
Well, no, not even an indirect role.
So nothing to do with exclusion orders?
No, that would be a matter for the Department of Home Affairs.
Nothing to do with passports?
No, that would be a matter for
No
the
advice at all?
Department of DFAT.
Provided to any other agency in relation to the return of the ISIS brides?
No, other than the broad international law advice. So I should just qualify in relation to some legislative responsibilities, AGS may have provided advice to Home Affairs or DFAT as providing client services.
The Attorney-General signs off on consent to prosecute two of the brides in relation to crimes against humanity, some of the gravest offences that can actually be brought against a person. But the Attorney-General's Department doesn't have a lot to do with the ISIS brides.
Not in the sense of having any contribution to any operational understanding of their movements.
It was two women have been charged with offences of crimes against humanity, isn't it?
That's correct.
Yep. Were three women charged in total?
I believe there were charges against...
What was the third one charged with?
I think it was a declared areas offence, entry to a declared areas, but we'd have to check.
The declared area, for actually leaving Australia to go to a declared area. Is there any reason that they would all not be charged with going to a declared area?
We just couldn't comment on that. That it was entirely a matter for the operational agencies.
So what's the elements of the offence of going to a declared area?
We need to take that on notice.
Is it leaving Australia knowingly and going to a declared area? Is that the criminal offence itself?
We don't have it right in front of us, so we can either take it on notice or we can see if we can find it now.
See if you can find it, because I'd be interested to just work through what actually is the criminal offence itself.
At a high level, it is being present or entering and remaining in an area that has been declared.
Yes, exactly. It was quite a simple answer. And that is the criminal offence itself, leaving Australia to go to one of these areas. And the areas where these women were declared areas.
I think that's a matter for evidence that the operational agencies would be responsible for gathering. I know that when we were looking at these offences when they were first introduced, that was one of the challenges that was identified about being able to access the evidence to demonstrate that.
And given there is a matter before the courts, we would not want to comment at all.
Has any additional resourcing been given to the CDPP in the budget specifically to handle the crimes against humanity prosecutions?
The CDPP did receive continuing funding in the budget to enable them to strengthen the prosecution service generally, but not specifically for this.
It reflected the increasing complexity of the matters before the CDPP, so they were provided some additional resourcing, reflecting the many complicated matters they have. It was not funding that was targeted directly at a particular prosecution, but more the entirety of their caseload.
Right. But there was a line item to specifically go after veterans, is that right? To prosecute our veterans?
There's a continuation of funding for the Office of the Special Investigator.
Yeah.
And
so how much
associated
additional money
agencies.
was given to the Office of the Special Investigator by way of a line item?
I'd need a minute to...
Or could you find that for me, please?
And the Commonwealth Director of Public Prosecutions received $40.8 million over 2 years to uplift their prosecution capability.
But that was across the board. There was no specific allocation in relation to prosecuting people who turned their back on Australia, left our country, went to a declared area, joined a death cult, murdered people, potentially committed acts of terrorism. There was no line item for them, but there is a line item to prosecute our veterans. And could you just read out what the amount is to prosecute the veterans, please?
Senator, I can assist that there was $50.4 million in the budget, $44.3 million to the Office of Special Investigator, $2.5 million to the Attorney General's Department. I think that's largely for NSI-related work, and $3.6 million for the CDPP. And then in terms of the general funding that Ms Chidgey referred to, it was $37.3 million over 2 years from 26-27.
But none specifically for the ISIS brides, just for the veterans.
So the $37.3 million was specifically to strengthen its capacity to undertake criminal prosecutions on behalf of the Commonwealth.
Across the board, but the 44.4 was to go after the veterans.
The 44 was for the Office of Special Investigator to continue its
Go after
inquiries.
veterans, in plain English, so Mum and Dad Australia can understand.
Senator Cash. Can I?
Yep, absolutely, Senator
Thank you,
Shoebridge.
Senator Shoebridge.
Thanks very much, Chair. Can I ask where the government's up to in terms of responding to the recommendation from the Parliamentary Joint Committee on Human Rights for a Human Rights Act?
Senator, we'll just get the relevant people up.
Where are we up to?
Sorry, your question was in relation to where we're up to in relation to the Human Rights Act?
Yes, the recommendation from the Parliamentary Joint Committee on Human Rights, which I think was unanimous, that the Parliament legislate in this term for a Human Rights Act.
Senator, the government is continuing to give careful consideration to the recommendations in the Parliamentary Joint Committee report on human rights that contain the recommendation in relation to the Human Rights Act.
What does continue to give careful consideration involve?
Continuing to consider the recommendation, but in the meantime, Senator, you of course would appreciate that human rights are protected through a range of ways in Australia, both at the federal and state and territory levels.
I'm aware we don't have a Federal Human Rights Act. I'm aware that the government doesn't implement its OPCAT changes. I'm aware that the government hasn't implemented its privacy changes. I'm aware that the government hasn't done its PID responses. I'm aware that the government hasn't responded to the National Security Legislation Monitors review. I'm aware of all of these things, but here I'm asking about the Human Rights Act, what the government has done to operationalise its response to the recommendation for a Human Rights Act.
So I think, Senator, it is the case that the government is giving it consideration. In the context of other things that you mentioned, we should just note that the government has legislated a merit-based transparent appointment process for the Commission. It's actioned all recommendations from the Respect at Work report, and it's undertaking a review of the Disability Discrimination Act, amongst other things. So there has certainly been a number of reforms the government has
the one
implemented.
legislative reform you've said was that you enumerated in that list that's actually happened was some marginal reforms about appointments to what? To what agency?
And Respect at Work report recommendations were legislative as well.
So the merit-based and transparent appointment process was for the Human Rights Commission itself.
All right. I mean, literally nobody other than the government has ever mentioned that to me. It's not part of a public debate. People haven't been pressing for it. But there's a huge public campaign for a Human Rights Act. So could we get back on and ask about the Human Rights Act and get some answers about what's happening? What does active consideration mean? Are there like 5 people actively considering it? What does active
Senator,
consideration involve?
The report was carefully considered by officers within the Human Rights Branch.
That's past tense. Was. What did was produce?
There was a briefing prepared
For who?
for the Attorney General.
All right. And was the briefing given to the Attorney General?
Yes, Senator.
When was the briefing prepared and given to the Attorney
I have to take the
General?
exact date on notice, but I believe it was in the middle of 2025.
All right. And is the next step dependent upon a political decision from the government? Or are we waiting for further active consideration from the department?
I think it is a matter. We obviously engage with the attorney on a range of human rights related matters, but ultimately any decision around legislation is a matter for the minister.
So in terms of response to the committee, when you said being actively considered, that was using current tense, but now we've explored it. Actually, what that means was a briefing was prepared and given to the Attorney-General in the middle of 2025. Has anything happened since then?
The department hasn't done further work on it.
So
it's a matter for the government.
So, Ms Hay, when you said it's under active consideration, there's actually nothing happening.
Senator,
Nothing at all happening in the department.
Well, it's under consideration by the government. The
Well, active
department's
consideration
not
was
undertaking work.
what Ms Hay said. And by active consideration, you mean nothing happening at all in the department? Which that's not my understanding of active consideration.
Senator,
You see, I think nothing happening at all is not active consideration.
I think there's a distinction between what the department is doing and consideration that's being given by a minister.
Well, is it active in the minister? Like you gave a briefing like 12 months ago. How do you know it's active with the Attorney-General? Has the Attorney-General told you it's active?
it's a matter for government, Senator.
So it's not active at all. A briefing was prepared in the middle of 2025 and nothing has happened since from a department point of view. Now, maybe, the Attorney-General goes to bed at night and actively considers it, but have you been told of that at any point, Secretary?
Senator, I think obviously because we did briefing for the attorney, there is information there for her to support any further consideration.
And I'm assuming that briefing was part of a raft of briefs that were prepared for an incoming Attorney-General. Was that right? Or was it a bespoke thing?
It was subsequent to incoming briefing.
Minister, are you able to shed any light about the activeness or otherwise of the Attorney-General's consideration of a briefing she got in the middle of last year?
Well, if the officials say it's under active consideration, then I'm absolutely certain that's what it is.
Well, I think there's been a little bit of... That was the initial statement, but I think there's been a bit of water under the bridge since that initial statement, Minister, if you listened.
But look, I don't personally know what the current situation is, but I shall, as I always do, inquire and I'll come back to you.
Okay, thank you, Minister. Well, moving to another subject, in October 2023, it was a different world. We had President Biden, we had different prime ministers in I think in the UK. Back then, the Independent National Security Legislation Monitor published a review on the National Security Information Criminal and Civil Proceedings Act. The government is yet to respond to that review that was handed down in October of 2023. What's happened? Is it under active consideration?
We provided advice, I know, to the former Attorney-General on that, on those recommendations, and there haven't been decisions by government as to how to proceed on that act.
When did you provide that advice to the former Attorney-General?
We'd need to take that on notice.
All right. Well, given the National Security Information Criminal and Civil Proceedings Act is likely to get a bit of a run in the Ben Roberts-Smith prosecution, don't you think that there's an urgency to doing the review?
No, Senator.
So you're comfortable with none of the recommendations of the National Security Legislation Monitor having been implemented, even though that legislation is likely to be tested and run in, amongst others, the Ben Roberts-Smith prosecution?
We don't have any reason to think that there is an issue with its operational effectiveness that those recommendations would relate to.
Why are we now almost 3 years down, or more than 2.5 years down the track? Why does it take more than 2.5 years to respond to some fairly modest law reform as recommended by the Independent National Security Legislation Monitor? Why don't we even have a public response more than 2.5 years later?
Ultimately, that is a matter for government. What I can say about that Act and its parameters is that there are complex legal issues and constitutional requirements that relate to how that Act operates. So it is by no means straightforward.
But what's happened, so far as you're able to observe, since your department gave the former attorney a briefing? Do you know, has that been somehow transmitted to the current attorney? Is it being considered by the current attorney? Like, briefing a former Attorney General is not particularly helpful in getting reforms done. What's the current state?
Senator, that is the current state. The department could provide some further advice to the current Attorney General.
So you brief an Attorney General, that Attorney General leaves, a new Attorney General comes in, and there's no process to get that reform back on track. Because clearly a former Attorney General, regardless of what you might think about them, is not going to be much use in getting a government response.
So we haven't briefed the current Attorney General, and we can do so.
Well, the exposure draft for the Public Interest Disclosure and Other Legislation Amendment Whistleblowers Protection Bill, published in September, consultation closed in October of last year. October. What's happened to that?
That is a matter for government to decide on any timing for introduction.
Have you done a briefing on it? Have you provided the attorney with a briefing?
Yes, we have.
When was that?
We need to take that timing on notice.
Was it this year, last year?
Well, it's a different set of colleagues.
Well, then why don't we
who
find
might be able
out? Like, this is the department where things go to die.
That's just
Senator
not
Shoebridge.
accurate, Senator.
I don't think that comment is necessary.
Well, Human Rights Act don't even have a formal response. Independent National Security Legislation Monitor, we don't have a response. Public Interest Disclosure and Other Legislation Amendment, we can't move the consultation bill out. The Privacy Act reforms, tranche 2, like the list is endless. The list is endless of reforms that just never make it out of the department. What about this one, the Public Interest Disclosure and Other Legislation Amendment Whistleblowers Protection Bill? Where's that up to?
I said we'd provided advice to the Attorney General following the exposure draft consultation. My colleagues might be able to add more to that.
Susan McCaig, Assistant Secretary, Transparency Frameworks Branch. Advice was provided to the Attorney General after the exposure draft bill in November 2025 and January 2026.
So 2 tranches of advice, one in November and one in January, is that right?
Correct.
And is the department waiting on a decision from the minister? Is that where we're at?
It's a matter for government as to the timing of that bill.
Minister, do you know if that's been brought before to your attention as one of your ministerial colleagues?
Look, it hasn't recently been raised with me, Senator Shoebridge, but I do reject your characterisation of the department. I think the minister and the department have had a whole series of serious issues to deal with of late. I mean, the most significant of them, of course, is the aftermath of the terrible shootings in Bondi, which I know has occupied much of the minister's time. And I think, her role in all of that and the subsequent development has been very, very significant. And I think your characterisation of this department is not accurate. I think it's doing a whole host of really important jobs for the community, but they can't do everything at the same time. And I did try and explain to you before some of the problems that exist in government, which means that you can't solve every problem immediately.
Well, if you had to write a brochure, Minister, to explain to the people who elected you, the good burghers of South Australia who elected you, about the achievements of the Attorney-General's Department in the 4 years that you've been in office, what would be on it?
Well, the list would be so long, Senator Shoebridge. I couldn't possibly fill it in the time that we've got.
I agree you couldn't possibly fill it in because it'd be a blank page.
Eh?
It'd be a blank page.
Oh, now, come on. Look.
Well, I've given you the opportunity. What would you put in it?
Well, let's just start with some of the things like the National Anti-Corruption
That's going well.
Body.
That was probably not the one I would have chosen.
The one that the National Commissioner resigned from today.
Well, that's
after a lengthy public campaign of that one. Okay, so that's going on the brochure. The NAC's heading the brochure.
You say the government has done nothing in this space. I say the government
nothing
has
you'd put on a brochure.
A brochure.
Nothing. I'm asking you what you put on the brochure, and you put the NAC. And would you include Commissioner Brereton's resignation in your brochure?
I'm one of these people, Senator Shoebridge, that believes in telling it like it is, and if that's what you want to put on your brochure, then I'd be happy to include that.
Well, what else will go on the brochure?
Well, look, the list is so long. I'd have to,
take it on notice.
Take it on notice.
Yeah, I think that kind of sums it up. I have one other issue, which would finish my questioning in this round. Yep. But by all means, take on notice the brochure, Minister, and then we'll put it. I'll put it on a PDF and
I'll design
it
overnight for you.
Just put the list. We'll design it for you. On a more serious matter, I think I mentioned this to you earlier, Secretary, that on Wednesday of last week, a joint submission was made to the Attorney-General and to the AFP by Amnesty International Australia, the Australian Palestine Advocacy Network and the Australian Muslim Advocacy Network, calling for the investigation of Australian dual nationals who may have participated in hostilities in Gaza, given the incredibly credible findings and conclusions of international tribunals as to genocide happening in Gaza. Have you received a copy of that correspondence?
No, Senator, I haven't.
Has anyone in the department received a copy of the correspondence?
Yes, we have, Senator, and just to clarify, it was a letter to the AFP Commissioner.
Well, it was also provided, on my understanding, to the Attorney-General.
My understanding is the Attorney-General was CC'd.
Well, what, if anything, has the Attorney-General done in responding to not just this call, but multiple calls for Australian dual nationals who may have participated in war crimes, crimes against humanity in the conflict in Gaza? What, if anything, has the Attorney-General done to ensure that that prompt and thorough investigations have been made?
As you'd appreciate, Senator, that criminal investigations are very much a matter for the AFP, as the independent law enforcement agency.
What will you see in response to the war crimes findings of Commissioner, then Major General Brereton, in relation to Afghanistan? The Attorney-General and government stood up a standalone War Crimes Investigation Unit because of the seriousness of the allegations and because of the need for an independent expert body to undertake those war crimes investigations. Why hasn't something like that been done to investigate potential war crimes from Australian dual nationals who have participated in hostilities in Gaza?
The submission in question asked the AFP to take various actions, Senator, and issues about whether there are prospects for investigation are very much for the AFP to consider.
Well, has the AFP's put forward in the last 24 months perhaps they've come through the CDPP, recommendations for the Attorney-General's consent for a series of war crimes and/or crimes against humanity prosecutions. Have any recommendations come to the Attorney-General in the last 2.5 years in relation to potential prosecutions of Australian dual nationals who may have participated in war crimes or the like in Gaza?
So we would never comment on any matters that were not in the public domain. So I can't comment on any requests for consent to the Attorney-General that are not on the public record.
Well, why not?
Because that could be disclosing an investigation that is not in the public domain and before the courts. So I can't comment on that. I think what I can say in relation to this submission is that the request is very clearly directed to the AFP and is very much a matter that falls within the AFP's functions. Has
your department secretary provided any advice or given any direction to the Australian Federal Police regarding the exercise of universal jurisdiction in relation to alleged offences in Gaza?
Not that I'm aware of, Senator, but we'd have to take it on notice.
Has the AFP made such a request to you at any point?
Again, not that I'm aware of, so I'll take that on notice.
Was there engagement between your department and the AFP when the process was being set up to establish the Office of Special Investigator and a separate, distinct, well-resourced body to investigate war crimes following from the Brereton report?
I'd need to take that on notice. I wasn't in the department at that time, so I'd need to make inquiries. I suspect we were, if particularly from the perspective that the entity ended up in our portfolio. So I'm sure we were engaged to some degree at that time, but that was back in 20...
Yes, we need to check, Senator. I think we had some involvement, as did the Department of Home Affairs and the AFP, but would need to take on notice the details.
Okay, and my final question here is about, I think I indicated earlier, had questions about the AHRC's Speaking from Experience report that was released in June of last year, and recommendations to amend the Sex Discrimination Act to restrict the use of non-disclosure agreements in workplace sexual harassment cases. Is the government intending to respond to that report from the Australian Human Rights Commission, and is there any work being done to ensure that victims of workplace sexual harassment cases are not being silenced through NDAs?
So, Senator, whilst the officers are just coming to the table, I just reiterate the government does not do formal responses to Human Rights Commission reports. Obviously, we value the work of the separate commissioners and the Commission, and we have regard to them, but we don't do a formal government response.
Well, I mean, well, whether you do a formal government response or not, is the government working to address the concerns outlined in the AHRC's Speaking from Experience report, which had two aspects to it. One was preventing employers and others from using NDAs in workplace sexual harassment cases, and the other was actively legislating to prevent victim survivors being silenced through strategic legal action or SLAPs. There were two elements to it. Are you doing any work on either of those elements?
Senator, we are due to commence a statutory review of the Respect at Work Act, which will provide an opportunity to consider a range of issues. I'll see if my colleagues want to add to that.
Thank you. Yes, as Ms Chichi said, it is a topic that may be incorporated into the upcoming review, and in addition there's a second stream of work. The department will be monitoring the Victorian government legislative reforms that restrict the use of NDAs to identify and learn from that experience.
It may be considered in the review. So there hasn't even been a decision to incorporate the AHRC's Speaking from Experience report in the review. I mean, this is the AHRC's, from memory, it's the final part of what's been going for like a 5-year Respect at Work process with the AHRC. And you can't even tell me it's going to be part of the review.
Senator, what I can say, it is being considered as part of the proposed terms of reference.
Considered for the proposed terms. Will you be consulting on the terms of reference? Will you be doing any public consultation?
I'd have to take that on notice, Senator.
Secretary, do you think it would be a good idea to consult on the terms of reference for the review, including with the AHRC, who have been so integral in doing this work?
I'm confident we would be engaging with the Australian Human Rights Commission. The scope of any consultation is ultimately a matter for the Attorney-General.
Thank you, Senator Shoebridge. Senator Cash.
Thank you. Could I just ask some very brief questions just in relation to the resignation of the head of the National Anti-Corruption Commission? Just in terms of the inspector had opened her second formal investigation into Commissioner Brereton on the 6th of February 2026 for possible agency maladministration or officer misconduct. He's now resigned. Just by way of process, does his resignation terminate the investigation, or can the inspector continue to investigate and report on the conduct of what will be former Commissioner Brereton?
Senator, it would be my expectation that the inspector's investigation or inquiry continues.
Right.
And as I noted, Mr Brereton's resignation is effective 6th
on the 6th of July.
But notwithstanding that date, I would still expect the inspector to conclude her report.
Okay. Will the inspector's findings, if any, be made public regardless of whether Mr Brereton remains in office?
It's ultimately up to him. The legislation provides that ultimately the decision around publication of an inspector's report is a matter for the inspector.
It is a matter for the inspector, okay. I think we get the inspector tomorrow.
You do.
Tomorrow. Thank you very much. Just in terms of entitlements and payout, again, just by way of process, Commissioner Brereton was appointed for a 5-year term from the 1st of July 2023. The resignation takes effect from the 6th of July 2026, approximately 2 years early. What entitlements does he receive on resignation? Does he get a payout for the unexpired term in terms of what's the total cost to the Commonwealth, or effectively the Australian taxpayer, of his early departure?
Senator, we might need to take the details on notice, but I'm just in the normal course of events with in this situation when it's his resignation. There is no payout associated with
There's
that.
no payout?
Not for the purposes of compensation for being...
His terms.
the term being terminated early, whether or not there's some leave entitlements that have accrued. I think
Understood.
that category there may be, but there would not be a payout.
He wouldn't retain office facilities or anything like that?
No, Senator.
Okay.
You don't get an honorary NAC commissioner's appointment afterwards?
There is no such thing,
Okay, just checking.
Senator.
Yep.
Thank you, Senator Shoebridge. Senator Cash has the call.
I think it was.
No comedic
The Attorney-General has described Commissioner Brereton's contribution as invaluable, and yet this is a man who was found to have engaged in officer misconduct, who gave misleading statements to the Parliament, whose CEO had to apologise to the same Parliament for misleading evidence about his conduct, and who is the subject of a second formal investigation by the Inspector. Minister, does the Attorney-General stand by the characterisation of his tenure as invaluable?
Yes.
On what basis, given that, as I said, this is a person who has had, as the head of the National Anti-Corruption Commission, not one but two investigations, and one which has been found that the head of the National Anti-Corruption Commission himself engaged in officer misconduct and gave misleading statements to the Parliament? Is that what the government expects from the head of the National Anti-Corruption Commission?
Senator, I think you've got to look at the totality of the role that the Commissioner played over the last 3 years. And I'm sure that on balance that the characterisation by the Attorney-General is correct.
If we look, unfortunately, at his conduct over the 3 years that he's been there, as I said, he's now been subject to 2 investigations and findings by the Inspector. Did the Attorney-General ask Commissioner Brereton to resign?
Not that I'm aware of, Senator.
Do you mind if I ask one question?
Absolutely.
And sorry, Chair.
I'm sure that's my call, but thank you, Senator
Chair,
Shoebridge.
would you mind if I ask?
Absolutely,
just one
go for
question?
it.
The Attorney-General was the Attorney-General also given a copy of the draft report from the Inspector?
Not that I'm aware of, Senator.
Did you tell the Attorney-General about the existence of the draft report?
I think the attorney has been kept appraised, but that is by the Inspector herself.
Well, has there been any communication between the Attorney-General and Commissioner Brereton, between the Attorney-General becoming aware of the existence of the Inspector's draft report and up to, but not including, the resignation of the Commissioner? Was there any communication between the two of them in that time?
Not that I'm aware of, but we would need to take it on notice.
Thank you. I know that was 3 questions. Senator Cash.
So just going back to, did the Attorney-General ask Commissioner Brereton to resign, Secretary?
Not that I'm aware of, Senator.
Did the Attorney-General encourage the Commissioner to resign?
Not that I'm aware of.
Does anybody else at the table have any knowledge of whether or not the Attorney-General herself asked Commissioner Brereton to resign or encouraged him to resign?
No.
Okay. So, to the best of your knowledge, this was entirely his own decision?
To the best of my knowledge, yes.
To the best of your knowledge. Are you aware if any commitments were made to Commissioner Brereton by the Attorney-General in connection with his resignation?
No, Senator.
Just in terms of going back to a line of questioning from Senator Shoebridge, who will act as Commissioner from the 6th of July until a permanent replacement is appointed?
Senator, I will need to prepare some advice to the Attorney-General for her to make a decision on that.
Okay, that's the questions in relation to the resignation of the head of the National Anti-Corruption Commission. Can I just go on to, again, I was asking questions in cross-portfolio this morning, but I was then directed to this section of the program, and it was in relation to comments made by the Race Discrimination Commissioner in his official capacity about Australia Day. Can I just confirm that the Race Discrimination Commissioner's salary is $408,020 per year?
Senator, yes, according to the REM Tribunal website, that's the Commissioner's total remuneration.
Total remuneration. When does his term expire?
I would have to take that on notice, Senator.
Okay. The Race Commissioner's statutory functions are to promote equality between people of different racial and ethnic backgrounds, to protect people from unfair treatment based on race, and to conduct research and educational programs to combat racial discrimination. Does the department accept that the role inherently requires impartiality and the capacity to represent all Australians?
I think that would certainly be an element or an expectation of how people undertake the role.
And Minister, would that also be the expectation of the government, that the role inherently requires impartiality and the capacity to represent all Australians?
I think that's a reasonable assessment, Senator.
Minister, is the government satisfied with the performance of the Race Discrimination Commissioner?
Yes.
Yes. Is the government satisfied that the Race Discrimination Commissioner is contributing in a positive way to social cohesion in the country?
Yes.
Okay. Minister, are you aware if the Attorney-General has expressed any concerns to the Race Discrimination Commissioner about his performance?
No.
No. Secretary, are you aware if the Attorney-General, or alternatively even yourself, have expressed any concerns to the Race Discrimination Commissioner about his performance?
In terms of the first part of your question in relation to the Attorney, I'm not aware, but I can't speak definitively on that. In relation to myself, no, I have not had any concerns about his performance.
Okay. What role does the department play in oversight of the Australian Human Rights Commission's public communications and the conduct of its commissioners?
So, Senator, commissioners are appointed, they are independent of government. The Human Rights Commission is independent. I don't play a role, nor does the department, in oversighting them as such. Obviously, we work closely with the Human Rights Commission on a range of different initiatives, but I wouldn't characterise the relationship as an oversight relationship.
So in terms of a commissioner, in this case it's the Race Discrimination Commissioner acting in their official capacity, when they make certain statements, and I'll put some statements to you shortly, that may be inconsistent with government policy or that may not be consistent with what we've all agreed is the inherent requirement of impartiality in the role and the capacity to represent all Australians. Who would raise that with the Commissioner?
I think the way you frame that is a bit hypothetical, so it's hard to...
Well, perhaps I'll give you a statement,
Yep.
and that way we can then progress with not a hypothetical, but actual statements. So the Commissioner has made comments, public comments, on Australia Day, colonialism and whiteness. It was in an SBS podcast, and he stated this: on that day you're expected to kiss the flag or go away. We're all on stolen land and we actually need truth-telling about the history of this land. If our goal is a harmonious society, it would be a mark of respect to accept that this is not a day to celebrate and choose a day that is less divisive. Has the department raised any of these comments with the Commission, Commission President or the Race Discrimination Commissioner directly?
I have not. I have not heard that podcast. So what you're quoting there is the first time I think I've heard that. But I have not raised anything with either the President or the Race Discrimination Commissioner himself.
I can actually have tabled for you a copy of articles relating to the podcast, and I'll get my office to bring that up so you actually can see the transcripts of what has actually been said. Minister, do you think it's appropriate that the Race Discrimination Commissioner makes comments about Australia Day, that on that day you're expected to kiss the flag or go away?
I think I can state very clearly what the Australian government's position is on this, and that is that Australia Day should continue to be celebrated as it is at the moment. I note that the Race Discrimination Commissioner will be appearing tomorrow, and you can have an opportunity then to ask them directly those questions. Just on, while I've got the microphone, you asked a question about whether the Attorney-General asked the Commissioner to
Resign?
The answer is no.
Thank you.
Which
Okay.
is, I think, the response
you came back to, yep,
I gave you.
that's fine. This has obviously been raised now by a number of people. These comments came to light earlier this year. So the Race Discrimination Commissioner, on that day you're expected to kiss a flag or go away. We're all on stolen land and we actually need truth-telling about the history of this land. Do those comments concern you, Minister, that the Race Discrimination Commissioner, who is meant to be impartial in his role and represent all Australians, is doing podcasts stating that we're expected to kiss the flag or go away?
Well, that is not how the government would express its approach
So what do you do about one of your commissioners making those types of comments?
Well, that this person is not one of my commissioners as such.
Well, the government. Is the government appointment.
And I shall raise the issue with the Attorney-General and come back to you.
How does the department ensure that statutory office holders maintain impartiality?
Well, Senator, as I said, we don't have any formal oversight of the statutory office holders. It's an important element of the independence of the Australian Human Rights Commission and the individual commissioner roles. The legislation does not envisage that the department play any particular role.
So does that mean that the commissioners are able to say basically anything they like? I mean, there's got to be some parameters around what a person appointed by the government to a role actually says.
Well, I think there's accountability to the Parliament, obviously in terms of how they undertake their role, there's an expectation through the description in the legislation in terms of that, but the department itself doesn't have an oversight role.
Would you ever have reason, or are you able to raise comments with a particular statutory office holder? When you say, I'll read you another comment. Again, he's done this in his official capacity, so he's been paid by the taxpayer or appointed by the government. They're not personal comments. If they were personal, I'd leave them aside. Again, he says this about Australia Day. It is a day when colonisation began, which led to the first peoples being forced off their country and onto missions and reserves, genocidal acts, massacres, systemic child removal and more, he said. Again, are they not comments that you would raise and say, I don't think these are actually impartial? You have a remit to actually bring Australians together, and these comments are actually dividing Australians?
Senator, I don't have a role of monitoring the statements of the Human Rights Commission commissioners.
Minister, do you believe that the government-appointed Human Rights Commissioner should, in relation to Australia Day, which I fully believe is a day should be celebrated on the 26th of January, is a day when colonisation began, which led to first peoples being forced off their country and onto missions and reserves, genocidal acts, massacres, systemic child removal and more?
Look, I think I've indicated the government's view to 26th of January, and that is, it is the day that we should celebrate Australia Day. As to the particular comments of this Commissioner, I shall refer them to the Attorney-General and ask her to come back to you, Senator Cash.
As a member of the government, do you find that concerning, though, that your race discriminationer is saying, I mean, I find it insulting, to be honest with you, on that day you're expected to kiss the flag or go away, and in particular, the message that sends to our veterans who are currently serving overseas, who have served overseas, many who have given their life so that we can actually have the freedoms that we have here today, to then have a person paid $400,000 a year by the Australian taxpayer gets to say, in his public official capacity, on that day you're expected to kiss the flag or go away?
Well, these are comments that this particular Commissioner has made. I'm not the Minister responsible.
No, but you are a member of the government, and the government's got
I'm
to
a
have
member
a
of the government, but
on this.
But you know, I stick to my lane.
This is not about, with all due respect, Minister, this is not about sticking to your lane. I can tell you on behalf of the Coalition, without having to go to any other person, that we find those comments utterly reprehensible. Utterly reprehensible, and an insult to any digger who has fought for this country.
No, you're entitled to express your view, and you're entitled to express it forcefully, Senator Cash.
And so could you express the government's view then on these comments?
Well, the appropriate person to do that is the Attorney-General, because this particular Commissioner reports to the Attorney-General. I've indicated to you that I'm happy to refer the comments to the Attorney-General and to seek her response.
So as a Minister in the government, you do not have a response to these comments?
As a Minister in the government, we have a person who is responsible in the government for this particular minister, and that is the Attorney-General, and she appropriately should be the spokesperson for the government on this issue.
Does the government share your Racial Discrimination Commissioner's view about Australia Day, that it is, and I quote, not a day to celebrate?
Well, no, I think I've answered that question 3 times now, Senator Cash. The government believes Australia Day should be celebrated on the 26th of January, and we will continue to celebrate it on that day.
Another comment from your $400,000 a year paid Racial Discrimination Commissioner, again on a podcast. When it comes to January 26, it becomes so difficult because there's this undercurrent of nationalism, love it or leave it phenomenon, where people go, well, unless you're with us, you're against us, and so you've just got to go on January 26, you've got to go and kiss the flag or go away. Again, Minister, do you condemn those comments?
Well, as I've sort of already indicated to you, Senator Cash, you get an opportunity to directly put these comments to the Commissioner tomorrow. I've indicated to you that you keep referring to these comments. I'm happy to refer them to the relevant minister, which is the Attorney-General.
Are you honestly telling me, Minister, you do not have, and as a Minister in the government, a comment on whether or not these are actually appropriate?
Well, I think I've indicated to you already that the relevant minister in charge of this area is not me, it's the Attorney-General. She is the appropriate spokesperson for the government on these issues, and I'm happy to refer to her. And as I say, you get the opportunity yourself tomorrow to put these comments to the Commissioner. I'm
very happy to put them to the Commissioner, but this is about the government and their appointment, and whether or not I think when you go to the remit of the Racial Discrimination Commissioner, and in particular where we started, that we all agree that the role should be inherently require impartiality and the capacity to represent all Australians. Is he indeed doing that with these comments? I'll give you further comments. January the 26th is such a conflicted day. I think, well, what are we celebrating? We're all on stolen land, and we actually need truth-telling about the history of this land. Minister, is it the government's position that we're all on stolen land?
It's the government's position, Senator Cash, that we should continue to celebrate the 26th of January as Australia Day. As far as the particular comments of this Commissioner, again, I'm happy to refer them to the Attorney-General for a comment back to you.
The National Anti-Racism Framework, which was released in November 2024, states this: Our systems are built to maintain white privilege. Those who are white can successfully navigate, access and lead systems and institutions without having to shed their language, culture, religion and other parts of themselves. That is actually in the official national anti-racism framework. I will read it again. Our systems are built to maintain white privilege. Those who are white can successfully navigate, access and lead systems and institutions without having to shed their language, culture, religion and other parts of themselves. Minister, does the government agree with their Race Discrimination Commissioner that our systems are created to maintain white privilege?
Well, as I said, and the answer is going to be the same to all of these questions, Senator Cash, that the appropriate person to respond to these comments is the Attorney-General, and I will ask her to come back.
I find it absolutely astounding that you have, as a senior government minister, no opinion yourself on this. Again, I can tell you on behalf of the Coalition, we do not agree with those comments. You could ask any Coalition person and they'd say they do not agree with those comments. You're a senior government minister, Senator Farrell, and you have no opinion on behalf of the government in relation to whether or not these comments are indeed appropriate.
Senator Cash, I think the minister has indicated that he will ask the Attorney-General to respond to the questions that you've put to him, as she is the appropriate person to respond to the questions.
This is a government-funded document, the National Anti-Racism Framework. But I'm not going to get an answer.
Oh, you've got an answer. It's just one you don't
It's one of deflection. It's one of deflection. I take no responsibility. I have no opinion on behalf of the government.
That is not the correct assessment of what I've been saying, Senator. I've said that there is an appropriate minister to speak on behalf of the government, and it's the Attorney-General, and I'm very happy to refer these questions to her.
I asked you at the beginning whether or not you were satisfied with the performance of your Race Discrimination Commissioner. Given these comments, does the government continue to maintain satisfaction in his performance?
Yes.
So you don't have any issues with the Race Discrimination Commissioner and his public comments basically denigrating Australia Day?
Well, you've asked the question, do we have confidence in this individual? And I've given you the answer, yes.
You do?
In terms of the...
Despite those comments?
In terms of the comments, I have told you I will refer them to the Attorney-General, and she can respond on behalf of the government to the issues that you have raised.
Thank you. I now do need to move on in the interest of time. Could I go on to the IRGC and an update since listing as a terrorist group?
Yes, to the extent we can assist. Yes. Yeah.
Is the department aware if the CDPP received any briefs of evidence relating to alleged IRGC support since the 27th of November 2025?
I'm not aware, but I also wouldn't expect to necessarily be
They
aware.
wouldn't necessarily provide you with...
And we wouldn't ever comment on something that wasn't public.
Has the CDPP received additional resourcing in this budget to handle state-sponsored terrorism prosecutions?
I think it's just got the general funding that we discussed earlier.
Oh, so none specifically to handle the state-sponsored terrorism prosecutions if they were to arise? Just the general line item of funding?
None specifically allocated to that,
yeah.
but a general, an increase, sort of funding available to generally uplift their prosecution capability and capacity.
Is the department aware of what guidance the CDPP has issued on prosecuting offences under Part 5.3A of the Criminal Code?
No.
You don't have any oversight in relation to that? You don't make any inquiries as to what they may or may not be doing?
No, and they'll be appearing tomorrow, so can answer any questions on what they do.
Okay. Would you then have any knowledge of whether any financial transactions, business arrangements or assets linked to the IRGC have been identified, frozen, blocked or unwound as a result of the listing?
No.
So in terms of the listing and the department's ongoing role, is there any ongoing role of the department?
So we administer the legislation.
Yep.
And so, as with all of the criminal code, if agencies at any point identify any issues with operational effectiveness, we engage with them on that. And if there's a need for proposing legislative amendments, we would do so. But the operational elements are for Department of Home Affairs and AFP.
Right, so in terms of the listing's now been undertaken, but there's no further role for the AG's department. It's the CDPP or Home Affairs.
Yes, so the Minister for Home Affairs makes the listing decisions and the AFP would investigate any contraventions of criminal offences.
Right, okay, that's fine. Could I jump to the Combating Anti-Semitism, Hate and Extremism Act 2026? So 2 organisations publicly have now been listed as prohibited hate groups under the new framework, Hizbut Tahrir and White Australia. What criteria was applied in determining the order of listings and what role did the department play in that assessment process?
Sarah Samios, First Assistant Secretary, Integrity and Criminal Law. So the taking forward the listing proposals, it relies on first the Director General of ASIO making a recommendation to the Home Affairs Minister, the Home Affairs Minister forming a view, sorry, the AFP Minister, I should be clear, forming a view and seeking the Attorney General's agreement. So that point at which the Attorney General's agreement is sought is our point of engagement.
Okay. So just in terms of the CDPP again and receiving, say, briefs of evidence, etc., from the AFP relating to any offences under the prohibited hate group framework, since in particular Hizbut Tahrir, I think that came into effect on the 6th of March of this year, would you have any oversight of that, or are those questions they need to be put to the CDPP?
Similar to the evidence around the state sponsors, similar situation applies. Yeah.
The Thomas Sewell High Court challenge, is that still on foot?
Yes, Senator.
Okay. The interlocutory hearing is listed for the 2nd to the 5th of June and the full constitutional hearing in September.
I believe those were the orders of the court.
Has the Attorney General intervened in the proceedings?
I think the Attorney General's a respondent in the proceedings.
The respondent to it, okay.
A respondent. There are 2, well, technically 3 respondents, I think, although we think one is misconceived.
Okay. Do you have an estimated cost to the Commonwealth of defending the High Court challenge?
Not at this stage.
Okay. Has there been any expenditure to date?
I don't think we would have been billed, but work has been undertaken because there has been a hearing.
Right, okay, so you haven't billed any work then, and we could follow that up. Okay, that's fine. The next estimates then. Has the department sought additional funding or drawn down on any existing litigation contingencies for this, or it's too early in the process to?
We don't have a specific fund for this litigation.
So should say there was some funding in the budget.
Specifically for this?
Well, not specifically for this litigation, but for this regime.
For the right. Okay.
Yes.
So what was that? Just remind me what that was.
I don't think I have the exact figure in front of me.
Is it the figure that I read out?
No, it's
about 650 over 2 years.
Yeah, we might take it on notice to give the exact figure. It's we think in the order of 600 to 700.
Sorry, I've got it here. It's funding of for the Attorney General's Department. It's 654,000 over the next 2 financial years, provided to the Attorney General's Department to support the implementation of the regime.
Okay, beautiful.
It's not specific just to litigation.
Oh, it's to support the regime more generally. So what would that entail then? If it's not just for the litigation, what would that also entail, the 654,000?
So if there were sort of any other issues identified with administering the legislation that the department needed to work on.
Okay. Okay, the balance of those questions will go to CDPP tomorrow. Can I now turn to the Commonwealth Parole Board implementation? Can I get an update on the implementation of the Commonwealth Parole Board following the passage of the legislation?
Thanks, Senator. Luke Brown, Assistant Secretary, International Cooperation Unit and the Commonwealth Parole Task Force. You're correct, the legislation passed the Parliament earlier this year to establish the board. Broadly speaking, there's 5 streams of work to establish it.
Yes.
Obviously the legislative process, which has largely been finalised. The appointments process for members of the board. Work around the fit-out and operationalisation of the board, as well as...
What does that mean, the fit-out and what does that mean?
Sorry, things like property, ICT, a location for the board to meet and those sorts of things, as well as the development of a case management system to enable the board to be able to do its work as effectively as possible.
Okay. Is there a confirmed commencement date for the board?
Not at this stage.
Is there an anticipated, like 6 months, 12 months, 18 months, given the stream of work?
The legislation says that the board would be established within 12 months.
It's within, it is, so there is a 12-month period. Okay, within 12 months. So at this point in time, it sits with the Attorney-General.
That's
parole
correct.
Decisions still.
Parole decisions are still made by the Attorney-General.
The Attorney-General. Did the Attorney-General have any delegations in relation to parole decisions?
She has delegated those decisions to a number of senior executives within the department.
Does the Attorney-General make any parole decisions, or they're all delegated?
No, the Attorney-General does make parole decisions. While she has delegated all parole decision-making functions to the department, the Attorney-General, consistent with previous Attorneys-General, has elected to make decisions related to terrorist offenders.
Yeah, the terrorist offenders, but not like child sex offenders?
No, generally speaking.
That's delegated to the department. Just in terms of the Commonwealth Parole Board, how many positions are there on the board?
The legislation sets a minimum of a chair and a deputy chair and at least 3 sessional members. We would anticipate, Senator, that there would probably be more sessional members, and by sessional members we mean part-time members.
Right.
Simply to just be able to facilitate the number of meetings that would need to happen, given those individuals would be part-time.
Right, okay. But chair and deputy full-time?
Full-time.
Okay. Has recruitment for all positions commenced?
Processes are underway consistent with the whole of government guidelines on appointments.
Can I ask, what does that mean?
Let me start with the sessional member process. Positions for those were advertised in January and in December and January of this year.
Yep.
December of last year and January of this year, and we're in the process of finalising a panel to assess those applications for that process to move through the recruitment stages. In relation to the appointment of the chair and the deputy chair, that's a process that we're engaging with the Attorney General on. And I think what I could say is that it's underway and a matter for government.
Just in terms of the advertising, they're advertised in December and January. When did the legislation go through?
Sorry, Senator, let me just confirm.
Senator,
passed on the 1st of April.
The 1st of April. So the advertisements were placed in anticipation of the legislation going through?
That's correct.
Okay. What qualifications and experience will be required? And can we take each position separately, the chair, the deputy chair, and then the sessional members?
So for the chair and the deputy chair, Senator, it's an either or. One of them must require legal qualifications, but not both. And consistent with other positions across the statute book, a minimum of 5 years post-admission legal qualifications.
Okay, and then, so that's either or, then what does the other one have to have?
Bear with me for a moment, Senator. So when appointing members to the board, the Attorney-General must ensure that the board possesses an appropriate mix of qualifications, experience and knowledge. And the appropriate qualifications and experience and knowledge includes, but is not limited to, I'll read it out for you, law enforcement, matters relating to victims of crime, corrections, medicine, including psychiatry, psychology, social work, counselling or mental health, including forensic psychology, and criminology or sociology or another relevant field.
And that's for all of them?
Yes, not limited to, it's a non-exhaustive list.
So the legislation requires the board to, and I quote, reflect as closely as possible the composition of the Australian community. What criteria are being applied in the appointment process to affect that? And how is professional corrections, judicial law enforcement expertise being weighed in alongside that requirement?
Senator, I think it's a general proposition that federal offenders represent diverse parts of the Australian community, and that those that to a certain extent, to the extent that it's possible, that there is representation from communities, particularly vulnerable communities, potentially to be part of the board, is what the intention of the legislation is.
I might just add, Senator, that the position is that community safety will be a primary and priority consideration for the board, so we would expect that corrective services and policing expertise would. So
you wouldn't want to just let a
significant
sex offender out? You'd want someone who has half an idea of the types of crimes they've committed. As a former Attorney General, you know that I used to look at these. I don't think I ever let anyone out on parole. So I am very familiar with the types of offences those people commit. They are horrific. That's why they're federal offences. So, yes, you will ensure that people actually understand the nature of the crimes.
That's right.
Will the government consult with victims groups before appointments are made?
So certainly in the design of the legislation and the model of the board, we have done extensive consultation, including with various victims of crimes groups.
Can I get on notice a list of those victims of crimes groups?
Certainly, Senator.
And in particular, given again, I know the briefs that you used to present. They're very in-depth. There's a lot of information in them, and in particular with the types of offences that we are talking about. What security vetting will board members undergo?
So we would anticipate that at least the chair and the deputy chair would hold national security clearances, so NV1 or NV2 clearances. In relation to other members, we are anticipating that at least some of them would need to hold those as well, simply to be able to have a quorum of decision makers in relation to a matter that would require that. We will also go through the usual quite rigorous due diligence process in assessing candidates before any formal recommendations are put to the Attorney-General.
Can you just remind me, will the parole board, the Commonwealth Parole Board, deal with terrorism-related parole decisions, or does that remain with the Attorney-General given the nature of the offences?
No, the parole board will have responsibility for all decisions, including terrorist decisions.
Right. So presumably then they will be accessing classified national security information given the nature of a terrorist offence. Will there be a requirement for any person looking at a terrorism-related parole decision to actually be cleared to the highest level?
At the moment, we think at least an NV2 clearance, negative vetting 2
NV2,
clearance, would be sufficient to be able to make those decisions.
One of the issues that is constantly raised, obviously, takes a very long time to get one of those clearances.
Yes.
Have you factored that into the fact that the board needs to be up and running within 12 months?
Certainly, Senator. That's one of the things that we have factored into the process of appointments. So
then is that meaning you'd appoint someone who already has one, which obviously limits the pool as to who you can appoint? But this is actually very serious. You're talking about parole for terrorists. So how is that going to work? You've advertised positions, but would the chair and deputy be appointments as opposed to advertisements to ensure that they do have the required level of national security clearance?
It could well be that they already have that level of clearance, or it could be that we would need to instigate a process where we would seek provisional clearances. But certainly what we would need to do to do this in the time that we would need to is run various processes in parallel, including a process of a national security clearance if we were required to do that.
One of the issues that we had raised at the time, and we certainly didn't support this legislation, but it's gone through, I accept that, is, and again, given the nature of, I've read these decisions, if a parole decision goes wrong and a dangerous offender is released and reoffends, who is directly answerable to the Parliament and the public?
Once the board is operational?
Yes.
The board.
The board.
The chair of the board.
So can you walk the committee through the accountability chain, and in particular, just, it is a hypothetical, but we have to work through it. A terrorist reoffends. The board has let them out on parole. How do we ensure the board is accountable via the Parliament?
Senator, there will be processes such as Senate estimates.
So the Commonwealth Parole Board will be coming before Senate estimates?
They are an independent statutory agency in the same way entities like the ARC are.
So will they come before estimates or not?
Yes.
Yes, Senator, would be my expectation.
Senator, I think it's also possible that perhaps the PJC on law enforcement could request that the parole board appear before it as well.
Would that be, though, in public or in private? I'm more interested in the public accountability of people potentially letting out offenders.
So I think the PJC does both private and public hearings.
Yeah, but will they appear before estimates? Because that's the first time I've heard that they're appearing before estimates.
I think our expectation is they could be called.
Okay, how do I find that out in terms of, is it in the legislation?
We can take it on notice, Senator.
Yeah, is it because of who they are?
Senator, it's not often, I don't think I've seen a provision in legislation that goes to that says anything about appearing before a parliamentary committee.
No, so I'm trying to work out. You've said to me
I think it's a matter for the committee.
But how? So we could call there is the ability for the committee to call the Commonwealth Parole Board before us.
I think I could assist, Senator, by construction of the legislation. The board will be a secondary statutory structure within the Attorney General's portfolio.
Thank you.
There's an appropriation to the board. I think in those circumstances, it would be appropriate for the committee to call it.
Thank you. Thank you. That makes more sense. Now, the board has immunity from civil liability for decisions made in good faith. Combined with the exclusion of merits review, does this weaken meaningful accountability in high-risk cases such as terrorism or child sex offending?
No, Senator. It's effectively the status quo. The same as what operates currently.
So, Senator, to add to Mr Brown's answer, that means judicial review of the decisions.
It is a judicial review of the... Yeah, okay. Is there a mechanism to correct a dangerous or unlawful release decision before harm occurs? So the parole board release a terrorist on parole because they decide to, or a child sex offender on parole because they decide to. Is there an appeal process? Or they've made the decision and the terrorist is on the street before their term is expired, or the child sex offender's on the street before their term's expired?
Yeah, that's correct, Senator. There's no appeal.
There's no appeal
process. Where, though, and speaking from experience, reports from a corrective services agencies or a community corrections officer that might be supervising someone in the community is made to the decision maker or the board. Steps can be taken to consider whether or not a breach has occurred, or at least to start taking some intervening steps to ensure that appropriate arrangements are starting to be put in place.
Will it need to be a unanimous decision of the board?
For
to release someone on parole or to keep them in?
It'll need to be a majority of the quorum, and it'll be up to the chair of the board to decide what number of board members it would that the chair might want to make a decision, for example, in relation to the release of a terrorism offender.
Okay. Will board members be subject to performance measures or KPIs?
Certainly, the board is required to table an annual report in the Parliament every year. I would imagine that report would need to report on number of decisions and the way it's performing against its budget and those sorts of things.
The Attorney-General has stated that the statutory prohibition against parole for terrorist offenders does not change. Is that true?
Yes.
Right. So the same criteria in terms of the existing law that prevents parole, so the presumption is against parole, is the same in this case for the terrorists?
Yes, that's Senator. Correct, Senator. The legislation that amended the Crimes Act, the transitional amendments, made no changes to that whatsoever. Section 19ALB remains as it is. As it is
now, okay. What training will board members receive on handling matters with national security implications?
We're turning our minds to the best way to do that, Senator. But certainly, if there are members that are unfamiliar with the national security community, that's something that we certainly would see as a really important thing to make sure that there is an adequate training program before they're onboarded.
And Senator, they'll be supported, the statutory office holders, by departmental staff, and we would expect that the full protective security policy framework.
Yeah, because it's a potential criminal offence if you're out there leaking national security information.
That's correct.
Correct.
Yes, so they need to understand all of this. What process exists for the AFP Minister or the Attorney-General to be notified before the board makes a decision affecting national security. So they're going to release a terrorist. They don't just release the terrorist out into the street.
Yeah.
What is that process?
Under the Crimes Act, there are provisions that enable, at the moment, the Attorney General, the Department, the Board, in due course, to be able to share information such as that.
Yes.
One of the standard operating procedures that we're intending to develop is exactly that in the event that an offender is released that is of an interest to another department, such as Department of Home Affairs,
You will ensure that the chain...
that they are advised.
And Senator, it's probably just worth making clear that as we've said, the existing presumption against any parole for terrorist offenders apply. In the rare circumstances where the exceptional circumstances requirements, the parole considered that was met. Obviously then if anyone is subject to parole, they're subject to intensive monitoring arrangements by corrective services, etc. So that whole framework would apply. Otherwise, most terrorist offenders are just released at the end of their sentence. And there's the sentence is just concluded at that point.
Yeah. Okay. What mechanisms are in place for victims of federal offenders to be heard by the Board before a parole decision is made?
So where a victim is registered, and that's through state and territory victim registers, submissions currently are taken, and we envisage that would be the same with the Board. I think it's fair to say that there aren't a large number of federal offenders that are victims that are registered, but where they are, certainly at the moment, the department makes every effort to ensure that they are able to make a submission. It's quite often the case that we find that the majority of them don't. But where they do, where they are registered, we seek to make sure that does happen, and certainly we are designing the Board to be able to do that as well.
Okay, thank you. Just in terms of the Board's decisions and including the reasons for granting or refusing parole in serious cases, will they be publicly reported? So I know you said there's an annual report. Will there be any other reporting mechanism for public awareness?
Specifically in relation to individual decisions, no. But what the annual report looks like will ultimately be a matter for the chair of the Board, perhaps providing information on an aggregated level.
Yep. Okay. And again, if they're preparing before estimates, we could ask them how many parole decisions have been made and what categories of the parole decisions being made, how many have been released, etc. Which can you therefore take on notice? How many parole decisions have been made by the Attorney General since she commenced in the role that released offenders? Oh, you're saying, hold on, the Attorney General doesn't make decisions, she's delegated them.
So the Attorney General makes decisions relating to terrorist offenders?
Yes, but the rest of it's been delegated. So sex offenders?
Yeah, so I can confirm that in relation to the decisions that are taken by the Attorney General, there have been no decisions to grant parole.
Okay. But in relation to all other offences, they're made by delegates?
That's correct, Senator, and I have numbers here by financial year. I don't have
Could you, just in terms of parole decisions made, can you give me information on that?
I can. Sorry, the total number of parole decisions.
And the time period we're talking about?
Okay, so probably the easiest way for me to do this for you, Senator, if we go with perhaps 2024-25. 1 July 2024 to 30 June 2025, there were 457 parole decisions made for federal offenders.
Yes.
In 241, parole was refused.
Yep.
In 216, parole was granted.
Yes.
I've got data up until the 17th of April 2026 for this financial year.
Yes, please. Thank you.
395 parole decisions to the 17th of April 2026. 243 cases parole was refused.
Yep.
And 152 cases parole was granted.
152 granted. Is it possible on notice to get a breakdown of the offences?
Senator, this is, and I know you've asked this previously.
I have, and I thought maybe
that we don't, just simply by the way that our current database and our system
it still
works,
doesn't actually allocate out sex offence.
It doesn't, Senator,
Yep.
and I did mention earlier the one of the really interesting pieces of work that we are doing with the establishment of the board is a new case management system that we do.
Yep.
I don't want to promise anything.
No,
but we do anticipate will be able to be used to provide much more detailed analytics in relation to the cohort.
Okay, thank you for that. And let me just quickly flick through. I've got some questions on modern slavery, which I'm happy to put on notice. Quick questions on the Legal Services direction. And my understanding is there was a decision made to approve a 43% pay increase for barristers doing government work. Is that correct?
Senator Philip Ing, Acting First Assistant Secretary from the International Public Law Division. I think what you're referring to there, Senator, is the increase in the council rate thresholds under the Legal Service Directions 2025.
Yes.
So one thing I should clarify is the threshold rates were increased, but they are not starting points for negotiation between the agencies and council. They are sort of reflective of thresholds beyond which the Attorney General or the Attorney General's delegate must approve those rates. So I can read those rates to you. They have not been. They were updated for the first time since around 2011. So
right. Okay. Yep.
And so they were increased significantly. Having said that, a couple of things remain. Firstly, that the rates paid to council by Commonwealth agencies remain a matter for negotiation between those agencies and council.
So when we say the maximum rate for senior counsel was raised to $5,000 a day, what does the $5,000 therefore represent by way of the negotiation? Can I go way in excess of that?
So what it represents is an approval threshold.
That's what it
Senator.
was. Sorry, right.
So beyond that point,
yes.
Either the approval of the Attorney General or the Attorney General's delegate, a departmental delegate, is required. What it does not preclude is the negotiation of appropriate rate where the Commonwealth achieves value for money for the Commonwealth between that agency and
understood. No, that makes a lot more sense. That's the negotiation rate. So in the last, say, financial year, what would be the highest per day rate the Commonwealth has paid a barrister?
I'll take that one on notice, Senator, and we can come back to you on that.
Would you mind? And then could I also have the average rates in the last 12 months that have been paid to a barrister?
Yes, Senator, we can take that one on notice.
Thank you very much. And I think, Chair, I can let you move on to the next section unless Senator Shoebridge has questions.
Only for the next session.
Oh, look at that. That's okay. Okay. And I've got a whole lot that can go unnoticed, but we need to move on to the Royal Commission.
Thank you, Senator Cash, for that. Before we do that, we had some documents that you wanted to table in relation to the comments from the Race Discrimination
just for the record.
Commissioner. So I'm just seeking
Thank you very much.
the committee's consent to do that. These are publicly available. I have checked both of those. So the committee tables those articles. It means that we are now in a position to release the Attorney General's Department. So
Thank you, Senator.
thank you very much, and we'll take a very short suspension while we welcome the Royal Commission to the table.
Thank you.
Sorry, Minister. I've just resumed broadcasting. Minister's got a quick statement that you wanted to make. Is that right?
I was asking, is there enough time to go to the bathroom before?
Oh, sorry. No.
Yeah, we don't want to turn
Sorry.
on broadcasting. It would be
No, let's not turn the broadcasting on down. Sorry. Promise this will be about government policies and expenditure, I'm sure, this time.
Chair, I do have a clarification I'd like to...
I thought you might have a clarifying statement, Minister.
Thank you. The question was asked earlier about the timeline for when the Attorney-General provided her consent to prosecute Australians returning from Syria. I can confirm that in relation to the consent to prosecute, the brief was provided by the Attorney-General's Department to the Attorney-General on the 11th of December 2025, and the Attorney-General provided her consent on the 15th of December 2025.
So the 20th of November?
No.
What happened there then on the 20th of November?
I'm not sure. I can...
Is that a right? Because I was given the 20th of November to the 15th of December.
Yes. Well, I think I'm clarifying those dates, but if that's not the case...
Would you, just check when you're ready. Thank you.
I shall provide you with the advice on that.
Thank you.
Thank you, Minister. I now call our witnesses from the Royal Commission on Anti-Semitism and Social Cohesion. Ms Sheehan, would you like to make an opening statement?
Thank you, Chair. I do have a short opening statement. As the committee knows, the Royal Commission was established on the 9th of January to report by 14 December. I'll cover in a brief opening statement where we're at with our work, approximately a third of the way into the inquiry. Upon establishment of the Commission, immediate steps were taken to assure that we were up and running as quickly as possible. This included appointing counsel assisting and solicitors assisting, finding premises for the Commission to operate from, procurement of key service providers, including a legal team to support the Office of the Solicitors Assisting and an e-courts provider to support the Commission's hearings. Our website and contact email was live within a few weeks of operation. Immediate steps were taken to fold into the Royal Commission the team that had been established to undertake the independent Commonwealth review into Australia's federal law enforcement and intelligence agencies. In this respect, the Commission began issuing notices in mid-January to take forward that work under the auspices of the Royal Commissions Act framework. Recruitment has been a high priority, and we have now reached a team of 90 staff across various teams, including legal, policy and research, community engagement and corporate. A key focus for the Commission early on was the delivery of the interim report due by 30 April. As the committee will be aware, that report has been delivered and included 14 recommendations. The hearing block that got underway today is focused on the issues raised in the interim report. An opening hearing was held on 24 February. During that hearing, the Commissioner announced that the Commission was opening for submissions from individuals and institutions addressing all of the terms of reference of the Commission. We have had a very strong response to that call for submissions, with more than 13,000 submissions received to date, more than any previous Royal Commission. I would like to thank those members of the community that have shared their stories with us. With submissions closing on 14 June, we are undertaking community engagement activities to ensure that the community understands our work and has had the opportunity to engage with us by making a submission if they wish. We have held our first hearing block, a key focus of which was hearing from Jewish Australians on their lived experience of anti-Semitism. As I've noted, we've now commenced our second hearing block and are actively planning future hearing blocks to cover all of the Commission's terms of reference. We look forward to answering questions from the committee.
Thank you very much. We'll proceed.
Are we able to have that circulated?
I'm sure we can. If we can
you
can provide a copy to the Secretariat and we'll have it circulated, that's okay?
Yep, sure.
Thank you very much. We'll proceed to questions and I'll begin with Senator Shoebridge.
Thanks, Chair, and thanks for your attendance today, Ms Sheehan, and your team. The Royal Commission's terms of reference expressly extend to recommendations that would strengthen social cohesion and countering the spread of ideologically and religiously motivated extremism in Australia. To what extent is the Royal Commission considering anti-Muslim hatred and religious and ideologically motivated extremism, radicalisation and de-radicalisation and radicalisation that's targeting the Muslim community?
Thanks, Senator. The Commission will hold hearings to look at all of its terms of reference. So future hearing blocks will be looking at of issues of ideologically and religiously motivated extremism and de-radicalisation. So that will, the precise detail of what's included in those hearing blocks will, is still being worked through.
Well, is that going to look at right-wing extremism and hard-right ideological attacks against the Muslim community? Are you going to have express extension of your hearings to include what we've seen repeatedly, this hard-right ideological attack against the Muslim community?
The focus of the letters patent, the terms of reference, is on anti-Semitism, and so that is the key focus of the Royal Commission.
But the terms of reference expressly say and empower the Royal Commission to make any other recommendations that would contribute to strengthening social cohesion in Australia and countering the spread of ideologically and religiously motivated extremism in Australia, separate to the other express and detailed references on anti-Semitism. So am I to understand from this exchange that you're not intending to have hearings looking at that anti-Muslim hatred, that Islamophobia that appears to be so prevalent in parts of our community at the moment? That won't be a separate hearing block.
Senator, I think you're referring to term of reference D, which refers to make any other recommendations arising out of your inquiry into the matters set out in paragraphs A through to C. So that reference to strengthening social cohesion in Australia is through the lens of the primary terms of reference into anti-Semitism.
So it's the view of the Royal Commission that, notwithstanding the broad reference there to ideologically and religiously motivated extremism, that you're only looking at that to the extent that it targets one religion.
The terms of reference explicitly refer to the term of reference D being linked to the other terms of reference A to C. This was something also the Commissioner touched on in her opening statement in our opening hearing on the 24th of February. And she referenced essentially what I'm saying now as well, which I can find that reference.
If it's on the public record, I can find it myself, Mr. Chair.
It's towards the end of the Commissioner's opening statement at that opening hearing, where she says, she expects that social cohesion will be advanced by measures that address discrimination against religious faith, ethnicities and cultures generally. Nonetheless, against the background of the massacre of innocent people who appear to have been targeted simply because they were Jewish, I trust everyone will appreciate why the focus of the Commission will be on tackling anti-Semitism as a starting point in strengthening our bonds of social cohesion.
Well, yes, as a starting point, now having seen multiple submissions from the Muslim community, from NGOs, pointing out the link between false claims of anti-Semitism directed against members of the Muslim community and others, and the attacks on the Muslim community, has that led the Commission to consider having hearings about the attacks on the Muslim community?
I think it's fair to say that the Commission's inquiry will be focused on anti-Semitism, and there may be recommendations that go to term of reference D around social cohesion more broadly that are linked to what the inquiry has found through its consideration of anti-Semitism.
Well, in hearing block 1, there were dozens of witnesses who characterised basic Palestinian advocacy, things like bake sales, wearing a keffiyeh, showing the Palestinian flag, calling for boycott, divestment and sanctions, characterised those actions of Palestinian solidarity, falsely characterised them as anti-Semitic. They were not challenged in any way by counsel assisting. How was that allowed to happen? Falsely stating that simply somebody wearing a keffiyeh was somehow anti-Semitic and yet not challenged by counsel assisting. How did that happen?
The main purpose of hearing block 1, there were a variety of witnesses that appeared during that hearing block, but was to hear from Jewish Australians on their lived experience of anti-Semitism, and it was an opportunity for them to share their stories of issues that they had faced.
Some of what the evidence was appalling, terrible acts of anti-Semitism, and absolutely compelling evidence, examples that should be closely followed by the Royal Commission and chased down. But to suggest that somebody on a university campus wearing a keffiyeh was evidence of anti-Semitism, or somebody doing a bake sale or demonstrating or having a Palestinian flag, to conflate those as anti-Semitism, those false conflations of anti-Semitism is one of the reasons why the Muslim community is being attacked at the moment. How would those allegations of anti-Semitism without substance allowed to be unchallenged? Is this what we would expect to see going forward?
I think you're getting into the substance of the way the Commission is conducting its inquiry. Hearing Block 1 heard from, a number of individuals who have experienced anti-Semitism, and we heard accounts of their stories. In the second week of hearing Block 1, we also heard from a number of organisations and institutions that went to issues around the definition of anti-Semitism, where some of those issues around precisely how would you define anti-Semitism, taking into account the overall context, was heard.
Well, false claims of anti-Semitism, wrongly conflating criticism of the actions of the State of Israel or basic acts of Palestinian solidarity, wrongly conflating them with anti-Semitism, is part of what drives Islamophobia and attacks against the Muslim community and attacks against the Palestinian community. But they were left unchallenged in the Royal Commission itself, when you're meant to be talking about social cohesion and fighting radicalisation. Left totally unchallenged by the Royal Commission. And now you tell us that you won't allow the Muslim community to come in and give evidence about their experience like this. How is this a balanced Royal Commission?
The Royal Commission has to operate with the terms of reference that it has set out in the letters patent, and the focus in those letters patent is on anti-Semitism.
Well, any matter reasonably incidental to a matter referred to in paragraphs A to D. What we're discussing now is obviously reasonably incidental, and yet is it going to be unexplored by the Royal Commission? Is that what your evidence is?
My evidence is that the focus of the Royal Commission, as set out in the letters patent, is on anti-Semitism.
Could I ask about secrecy law changes? Commissioner Bell raised very real concerns about witnesses from security agencies being unable to give frank evidence due to Commonwealth secrecy provisions. There's now been some law reform in the space, providing immunity to only a handful of those secrecy provisions. Does the Commission consider the protections in that recent law reform, which I think was called Protections for Providing Information Act, does the Commission consider those protections sufficient to allow all current and former agency members to give full and frank evidence?
The Commission was very supportive of those amendments being made. I think they addressed the key barrier that we were aware of in terms of secrecy provisions, posing a barrier to both agencies providing information to the Royal Commission, but also individuals. And with those,
are they sufficient?
We have not experienced problems with individuals being able to put information forward to the Commission.
Well, the bill requires relevant agency heads to voluntarily enter into arrangements with the Commission before their current or former staff are protected. Have all relevant agency heads entered into such an arrangement?
Yes, there's 2 arrangements in place and they're both on the Royal Commission's website. Do
they cover all the agencies the Royal Commission needs covered?
Yes.
Have any witnesses declined to give evidence or given qualified or limited evidence because they were uncertain about whether they had protection?
No, we only held one hearing block so far, so the witnesses that were relevant to hearing block 1 would not have been relevant, but if you're, so maybe witnesses is not the right.
Well, perhaps when I say witnesses, I mean anyone who is not just being called formally as a witness, but anyone who's seeking to give evidence or provide a submission, have any of them indicated that they didn't feel comfortable to give full and frank evidence in either a submission or otherwise because of the lack of adequate protections from potential prosecutions for secrecy breaches?
We haven't had that concern raised with us.
Can I ask about the situation on security clearances? The Royal Commission Legal Assistance Service, do the solicitors or the support staff on that have security clearances?
The legal advice scheme and the legal financial assistance scheme that's set up for the Royal Commission is administered by the department.
Secretary, do the solicitors and others providing advice on the Royal Commission Legal Assistance Service, do they have security clearance? Somebody has indicated to my office that they have confirmation in writing that they do not. Do you know what the situation is?
So, Senator, the scheme that was established, we entered into an arrangement with National Legal Aid, I believe, and it is National Legal Aid that provide the legal assistance from people who apply under that program. I need to take it on notice, the specifics about whether or not they have security clearances. The officers who could assist with that have gone.
It's been asserted to my office that the relevant service has indicated solicitors do not hold a security clearance. If that is the case, Secretary, how can they give legal advice to people coming forward to the Royal Commission, given the subject matter of the Royal Commission would obviously regularly involve intelligence agency conduct, security operations, classified material? How can a witness get proper legal advice, disclose that matter to a lawyer if the lawyer doesn't have security clearance?
Senator, I'd like to take that on notice. Some witnesses obviously would be eligible under Appendix E assistance and be assisted by the Commonwealth arrangements. If they're not within that scope, then they could be receiving assistance through the legal assistance scheme that's been established and that the Legal Aid Commission is assisting with. So I'd like to take it on notice.
When you say Appendix E, is that a separate form of legal assistance where the lawyers have security clearance? Is that what you're referencing? I'm not familiar with Appendix E.
Not necessarily, but
Mr Ng might be able to assist with this.
Senator, it's Appendix E under the Legal Services Directions. It's now Part 9 under the Legal Services Directions 2025. What it provides for is that relevant former or current Commonwealth officials can apply for assistance from their accountable authority in relation to legal proceedings writ large that involve them in relation to in the course of their official duties.
Ms. Ng, does that mean somebody who is currently or formerly with ASIO can apply to ASIO for legal assistance? Someone formerly or current with the AFP can apply to the AFP? Is that how that works?
So there's the relevant decision maker will depend on the seniority of the person within the agency, but in general, if they are an employee or a former employee of the agency, the accountable authority is the person who decides. There are provisions around where that is not appropriate, but that's the general rule.
Well, so Ms. Ng,
Yes. And sorry, Senator.
Does that language mean? Does it mean what I understood it to mean? That if you were or are a current or former employee of ASIO, that the relevant authority for the purposes of, did you say Appendix E of the...
Sorry, it's Part 9 of the Legal Services Direction, Senator, but I should have clarified that there's only one scheme that is available, and actually the legal assistance scheme that has been described more generally would also be available.
But this was all about, my questions were all about security clearances. I understand that the solicitors for the Royal Commission Legal Assistance Service, which has been run out of legal aid, do not have security clearance. And therefore, how can somebody who's coming to the Royal Commission and wants to give evidence about matters that involve intelligence agency conduct, security operations, classified material, if their solicitor doesn't have security clearance with the Royal Commission Legal Assistance Services, where do they go?
So, Senator, we haven't had that issue raised with us. I mean, we can take on notice, or you could direct that person to us, and we can work through how we can assist them.
Well, as a general rule, people like to maintain their, particularly if they're whistleblowers, they don't much like being forwarded to the government when they raise concerns with members of Parliament in circumstances like this. People, it doesn't seem an unreasonable expectation that somebody at this table, either from the Royal Commission or from the department, can identify how somebody who's a current or former member of a security agency can get a lawyer to help them give evidence to the Royal Commission and ensure that that lawyer has security clearances so that they can actually get the advice they need. It doesn't seem unreasonable to ask this question, given the Royal Commission has been operating for many months now. And it seems odd that no one can answer it. Nobody at the table can answer it?
Ms. Gigi is going to assist.
So I think if the issue arose, the individual could go to the Royal Commission and then we could assist the Royal Commission with advice on a security cleared lawyer.
Has anyone approached the Royal Commission indicating their concerns that the profit assistance under the Royal Commission Legal Assistance Service only includes solicitors that don't have security clearance? Has anyone raised these concerns?
There are some individuals that we're engaging with as to how they can provide information to the Royal Commission under the auspices of the information arrangements that I mentioned before, so how they would be able to provide classified information to the Royal Commission in a means that's consistent with those information arrangements. And we're working through those issues. It's not so much about what legal advice
where do they
go
for legal advice? You can't refer them to the service because they haven't got security clearance. Where are you referring these people to for legal advice?
So we don't... There are legal advice schemes in place, but the Royal Commission does not provide legal advice to the individuals.
I'm not saying you do, but you must surely somewhere on your website, and I think I've seen it before, have reference to legal advice. You're referring people who need legal advice to the place they can go. Where do you refer people who need legal advice about evidence that is subject to secrecy provisions?
On our website, we refer individuals to the two legal service providers that have been set up.
Senator Shoebridge.
So, can I just finish with this? Secretary, can you provide on notice where on earth somebody would go to get a solicitor who's got the right security clearance so as they can be assisted to give evidence to the Royal Commission if it's subject to statutory secrecy provisions?
So happy to take that on notice, and Senator, I would always also suggest that if you wanted to suggest to the person who has approached you for them to at least contact the Commission, and then the Commission can work with us to ensure that we will seek to make arrangements for a security cleared lawyer.
They've already approached the legal service and got told that they haven't got security clearance and can't help.
If they approach the Royal Commission, we'll work with the Royal Commission.
Thank you, Senator Shoebridge. Senator Cash.
Thank you very much. Just in terms of the opening statement, you've said you've held your first block of hearings. a key focus of which was hearing from Jewish Australians on their lived experience of anti-Semitism. You've commenced your second hearing block and are actively planning future hearing blocks to cover all of the Commission's terms of reference. I'll get to that last part shortly. Just in terms of the hearings though, all of the hearing block ones were broadcast on YouTube and are still accessible. Hearing block 2, I understand, are only on the Commission's website and they're not on YouTube. And as of this evening, they're not on the website. Why are hearing block 2 not being broadcast on YouTube, and will they be uploaded to the website so they can be viewed?
They should. The webcast should be available on our website. So if it's not there, then it should be available shortly.
So there's no difference. There's no right.
We did change, and I might need to perhaps get some more detail from my colleague. From our first hearing block, we streamed through YouTube.
Yes.
And then I think it was at the beginning of this hearing block we have changed to streaming it through Vimeo, which is a...
Right, okay. So there was nothing deliberate, because I'm looking at if I look at your website now, I've got all of hearing block 1.
Yep.
But I will expect to see hearing block 2.
Yes.
And that, okay,
for the public
for the pub, sorry,
yeah.
Obviously for the public, yeah. Okay, thank you very much. I appreciate that. Just in terms of the latter part of what you'd said, we are actively planning future hearing blocks to cover all of the Commission's terms of references. Senator Henderson and myself and have written to you just in terms of some suggestions for hearings, and I think you've got the letter.
I do.
Can I then ask, because this has been raised with us now by so many different people, and in particular from the Jewish community, will you establish a dedicated hearing block into publicly funded arts institutions and broadcasters, including the ABC, SBS and Creative Australia?
Thanks, Senator. And I have received your correspondence and spoken with Senator Henderson a couple of times
excellent. Thank
as well. We are still actively planning our future hearing block, so I'm not in a position to say precisely what they're going to cover. What we have said is that we're going to regularly conduct hearings between now and August. We'll release further details of those hearings on an iterative basis. Our senior counsel has given a broad outline of what future hearing blocks would cover, so I can cover that now.
Just I'd specifically like to concentrate on the ABC in particular, and I'm assuming you've got room to move. Like, you don't lock something in stone.
Absolutely,
there's room to move. So, does the Commission accept that publicly funded cultural institutions do play a significant role in shaping social cohesion and public attitudes towards anti-Semitism?
We're receiving a lot of submissions on a range of issues, and as you say, that will help inform us what we need to hold hearings on. So we've said that future hearing blocks will address a number of case studies of anti-Semitism.
So would someone provide you with such a case study, or is that something that you would look at?
A case study would be something that our legal and counsel team develop, and it would be informed by the submissions that we're receiving. So we're certainly receiving submissions across all facets of life, and media, social media, arts and cultural institutions are certainly an area where we're receiving submissions.
Yes, and you did say there's obviously been, I think the figure was over 13,000 submissions.
Yes.
That you said you'd received. Will the Commission examine whether publicly funded institutions have responded adequately to rising anti-Semitism since October the 7th, 2023?
There'll certainly be hearing blocks, and part of our terms of reference step out government responses to anti-Semitism.
And when we talk about government responses, you use that in the broader term of government as opposed to the people sitting at the table, I'm assuming.
Yes.
Yes, yep.
Yeah. And there will be, I think, drivers of anti-Semitism is also part of our terms of reference as well.
Will the Commission investigate whether failures in governance, editorial oversight or cultural leadership within publicly funded institutions may have contributed to social division or diminished confidence amongst Jewish Australians?
That's probably going to a level of detail that I can't really, I guess, guarantee precisely what future hearing blocks are going to look at.
But you have indicated that you are looking at the publicly funded arts institutions and broadcasters more generally.
So we've certainly received submissions on all of those issues. We've said that we will look at future hearing blocks will address case studies, addressing a range of issues that we've heard through submissions. So it's certainly something that's being actively considered.
Okay. These are issues that are raised with me, and I mean, you've got the letter, but I do want them on the record. Does the Commission intend to examine complaints handling processes within public broadcasters where allegations of anti-Semitism or anti-Jewish bias have been raised?
I'd probably give the same answer, that it's sort of just a little bit too detailed for me to precisely say that that's exactly what a future hearing block will look at.
And as I said, I'll keep raising it though, so it's actually on the record of what people have brought to Senator Henderson and myself. Will the Commission consider whether existing editorial standards and governance frameworks within public broadcasters are sufficient to identify and address anti-Semitism?
I think I would give the same answer, Senator.
Okay. This one, you might be able to be a little bit more specific on this one. Does the Commission intend to examine why the ABC and SBS declined to adopt the IRHA definition of anti-Semitism endorsed by the Special Envoy, Ms Siegel, and used by the Royal Commission itself?
I think I would give the same answer, actually, just because we haven't released details of exactly what our future hearing blocks are going to consider.
No, that's okay. As I said, I'll still go through it, and I do understand what you're saying, but I just do want all of these issues raised on the public record in terms of what people are bringing to us that they would like the Royal Commission to look at. Does the Commission recognise anti-Semitism as a distinct form of resentment towards a specific community, or does it simply see anti-Semitism the same way we look at, say, conventional forms of discrimination?
I think I would say from the approach to the hearings to date that anti-Semitism has been looked at as as not just another, a distinct...
Yeah, it's a distinct form against, a specific community as opposed to the more generic form of discrimination. I'll then now just list a whole lot as opposed to putting it to you. But the issues that have specifically been raised with us, and you have indicated you are receiving submissions on the broader publicly funded arts institutions and broadcasters. I'll assume that means the ABC in particular, SBS and Creative Australia. So just in terms of issues that people have raised with us that they would like to see a hearing block into, whether publicly funded institutions should be expected to adopt nationally recognised frameworks for identifying anti-Semitism, whether taxpayer-funded arts organisations have appropriate safeguards to prevent anti-Semitism whilst at the same time balancing out artistic freedom, whether publicly funded cultural organisations facilitated or tolerated conduct that contributed to hostility, exclusion or intimidation towards Jewish Australians, whether current Commonwealth funding arrangements contain sufficient accountability mechanisms where anti-Semitism occurs within publicly funded organisations. This one has been raised by a number in terms of, does the Commission intend to examine whether public funding should be contingent upon organisations maintaining appropriate safeguards towards anti-Semitism? And you are hearing, can I confirm, directly from members of the Jewish community regarding their experience with publicly funded broadcasters, the arts organisations and cultural institutions?
We've had a really wide range of submissions, and we've certainly had submissions that relate to media.
People's own personal experiences with publicly funded
correct.
broadcasters. Other issues that are raised are examining whether institutional responses to anti-Semitism have been timely, transparent and consistent across the arts and broadcasting sectors. Again, I put that on the record as issues that are raised, and I would ask if you could take consideration of them. You've acknowledged that you are receiving submissions specifically going to the publicly funded arts institutions and broadcasters, including the ABC. So I would just hope that sooner rather than later, but that one of the hearing blocks that you're actively planning does actually cover what we've referred to tonight.
Senator Cash, just checking that indication for time before I share the
I was just
call.
going to ask, are you able to make any comments on the resignation of Dennis Richardson?
I guess it depends what the question is that you're putting to me. I can't speak for Mr. Richardson. He has spoken for himself when he did resign, and the Commissioner put out a statement the day that he resigned, so there wouldn't really be anything I think I could add to that.
For example, Mr Richardson said his work with the Commission needed to conform to the way the Royal Commissioner and Senior Counsel saw it, and that he no longer had the flexibility of an independent reviewer. Perhaps if I could put this to the Secretary, was the Department aware of this structural tension before Mr Richardson raised it shortly before his resignation?
Senator, I think it's accurate to say that we had a range of, as the former Administrative Inquiry, the Richardson Inquiry, was integrated into the Royal Commission, we had a range of discussions about how the structure of a Royal Commission would impact the approach that he had been taking. Obviously, a Royal Commission operates, consistently with the Royal Commission Act. There are procedural fairness requirements that come into play that don't necessarily apply in an administrative inquiry. So it was working through those type of issues, and I did meet with Mr Richardson on a couple of occasions to talk that through. And I think, some of those issues were worked through. Some of them, I think, once the Royal Commission was up and running and in full steam, the processes, including the procedural fairness requirements of the Royal Commission,
versus
the less formal approach of administrative review, I think, obviously the less formal approach had to make way for the formal approach required under the Letters Patent and the Royal Commission Act.
Okay. Did you want me to... I've still got a few more questions.
Yeah, is it worth maybe coming... Yeah. Thank you, Senator Cash, for your assistance. Senator Faruqi.
Thank you, Chair. Good evening, everyone. I just wanted to ask if it is correct that leave was not granted to the Australia-Palestine Advocacy Network to appear before the Royal Commission?
Senator, that's correct that leave was refused to appear at the hearing block 1. Mm-hmm. So the way that leave to appear applications work is that for each hearing block, we'll put out the Commission will issue a scope and purpose for each hearing block and invite any interested parties to apply for leave to appear. Those applications are considered having regard to the Royal Commission's practice guidelines, hearings, witnesses and leave to appear. the Australian Palestine Advocacy Network did apply. Leave was refused to appear at the hearing block. However, the Commissioner directed counsel assisting to serve their closing submissions on APAN and granted leave to file a submission in response.
Okay, and what about the Loud Jew Collective? Was leave not granted to the Loud Jew Collective to appear before the Commission as well?
That's correct. Leave was refused to the Loud Jew Collective.
Mm-hmm. I guess why I'm asking these questions is because there is a lot of concern in the community because the Royal Commission has made plenty of space for testimony conflating criticism of Israel with anti-Semitism and pointing the finger at the Palestine solidarity movement. You heard some examples earlier. There are plenty more. Do you believe refusing to hear from a full range of witnesses, and these witnesses are affected by the matters in front of the Royal Commission, it calls into question the Royal Commission's credibility on social cohesion?
Senator, leave to appear, so they're not seeking leave to appear as a witness, they're seeking leave to appear to then be represented at the hearing.
Yep.
Each of those applications is considered on their merits. So individuals and organisations have the opportunity to put an application together that's considered by the Commissioner. So it's very much dependent on the issues that they're raising in their application as to whether leave is granted. And on those two occasions, leave was refused. Was refused to the Loud Jew Collective, and leave was refused to APAN to appear at the hearing, but leave was granted to make submissions in relation to counsel assisting submissions.
Okay, and can you give me some specifics about why they were not granted leave, particularly?
No, I can't.
Why?
Because it's a decision of the Commissioner and she's advised the parties when they're seeking, sorry, not the parties, when the individuals or organisations are seeking leave, she advises them of the outcome, which she's done.
Okay. I guess that social cohesion, from where I sit, means, it is about connections and relationships between communities. And you were responding to the questions that were asked before about possibly there would be no room for, in this Royal Commission, to talk about anti-Muslim hate or anti-Palestinian racism or any of that. So how does the Royal Commission expect to address social cohesion with just a very narrow view being heard by the Commission? Can you explain to me how you expect to address social cohesion?
So I think there's probably a couple of different parts to your question. The issue that goes to our term of reference that relates to social cohesion, as I was outlining before, the letters patent themselves set out that it's through the lens of term of reference A through C, which specifically deal with anti-Semitism, through which social cohesion is to be looked at. So the Commission's role is to conduct its inquiry in light of the terms of reference that it's been given. In terms of leave to appear and whether organisations would have the opportunity to participate in future hearings, that's done for each hearing block. So, for example, if there's a future hearing block where that might look at other issues that might have individual would have more of a direct and substantial interest in, they can apply for leave for future hearing blocks, and that will be considered by the Commissioner at the time.
So the Australia Palestine Advocacy Network or the Loud Jew Collective could apply for leave to appear in future blocks, and then that could be considered again?
That's correct.
Yeah. There does seem to be a real flaw in the terms of reference then, because you can't address social cohesion or racism by just looking at one form of racism. I mean, surely that is something that is quite apparent to the Commission. During the hearings, the Commissioner referred to what international legal experts, human rights organizations, and genocide scholars have described as a genocide in Gaza simply as hostilities. combined with the exclusion of groups such as APAN and Loud Jews Collective from the hearings, do you understand why many people are becoming skeptical about the Royal Commission? Is that something you're concerned about?
No, it's not. I think that there's a lot of confidence in the work of the Royal Commission, and that's not something that's being raised with us.
Mm-hmm. Is there a reason that the Royal Commission is, I guess, ignoring or turning a blind eye to the fact that Amnesty International, Human Rights Watch, a UN Commission of Inquiry, and so many international legal experts have called Israel's killing of 80,000 Palestinians and the starvation of tens of thousands of others genocide? Like, has the government directed the Commission or the Commissioner not to use the term genocide?
No, there's been no direction to the Commission of that nature. The Commission's been conducting its inquiry based on the terms of reference set out in the letters patent. So it is not requiring the Commission to look at whether a genocide has occurred or not. The terms
That's
of
not
reference.
my question, though. Genocide has been referred to as hostilities.
I think I'm trying to explain why the hearings have focused on what they have. Mm-hmm. So our first block of hearings have focused on the lived experience of anti-Semitism, looking at the nature and prevalence of anti-Semitism, and that was largely what hearing block 1 was focused on.
Mm-hmm. But if they were looking at the lived experiences of anti-Semitism, why was the Loud Jew Collective not given leave to come?
Their application was considered by the Commissioner.
Mm-hmm. And denied?
And refused.
And you can't give me a reason why?
No,
a specific reason why?
Well, the broad reason was because they were not, based on their application that they submitted, it was not considered to have a direct and substantial interest in that hearing block based on their application.
Okay, thank you. Thanks, Chair.
Thank you, Senator Faruqi. Senator Cash.
As brief as possible so Senator Roberts can get to his questions. Director General Burgess appeared, I understand, at the Royal Commission.
Today, yes.
Yes. However, from the AFP, it was Assistant Commissioner Nutt. Is that correct?
That's correct.
Okay. Will Commissioner Barrett be appearing as her fellow agency head did in Director General Burgess?
We tend to release the witness lists the evening before each block of, each day of hearing, so we don't identify in advance
the witnesses that are
that are then appearing the next day.
Is that for security purposes?
It's for a variety of reasons, including because witnesses can just change. For very practical reasons, can change around depending who's available on what days.
I suppose for me, it's more so Director General Burgess had the courtesy to appear before the Commission. He is the head of. I suppose I would hope that Commissioner Barrett would also appear, given she's the head of the AFP, and it was such a significant issues that need to be worked through in terms of the AFP. Well, this won't be the only appearance from the AFP.
And no, there'll be. The Commissioner indicated this morning that there'll likely be about 3 days of public hearings this week, and then we'll move into closed hearings.
Right. Okay. So one might hope that we might see Commissioner Barrett, as I said, Director General Burgess was good enough to appear. In your investigative work so far, has the Commission formed views or a view on whether there is a meaningful distinction between anti-Zionism, understood as the opposition to the existence of the State of Israel, and anti-Semitism, hostility, resentment or prejudice towards Jewish people? And does the Commission consider that anti-Zionism can in practice operate as a disguised form of anti-Semitism?
I think it's too early to say that the Commission's formed views on these things yet, because we're still in the process of having hearings on these things and taking submissions. But certainly I can say during hearing block 1 there was evidence on differences between anti-Semitism, anti-Zionism. What does it mean, and are there differences? So that was something that was being considered.
Well, that's good. So it is being raised, but at this point in time, there's no formal finding or there's no recommendation from the Commission. Secretary, the government told Parliament that the Richardson review was being folded into the Royal Commission, as you've already discussed, so his work would strengthen the inquiry into intelligence and law enforcement failures. Mr Richardson has since said the interim report will be a very different document to the one I would have done. Did you have discussions with him as to what he actually meant by that statement?
Not specifically. I did speak to him after he had announced his resignation. We didn't go into the details of what that meant for the final interim report. But I think as the Royal Commissioner, or Commissioner Bell, acknowledged herself, she drew heavily on the material that had been provided by Mr Richardson, and I note that the team that supported Mr Richardson, Tony Sheehan, former counter-terrorism coordinator, Peter Baxter, Tara Inverarity, they continued on in the Royal Commission and assisted in the finalisation of the interim report.
Okay. For the 9 publicly available recommendations out of the interim report, can the government provide, or the department, the specific action to be taken, the lead agency responsible, the target completion date and the budget allocated in the 2026-27 budget on notice?
I think it's probably more a matter for Home Affairs. They're the lead agency on those recommendations.
Yep. Home Affairs, okay. Has the government established a formal implementation task force or interagency coordination mechanism?
Again, I would put that
Home
to
Affairs.
Home Affairs.
Which minister is the designated lead for the whole of government coordinated implementation? Home Affairs.
Home Affairs.
And again, this is probably something for Home Affairs. Will the government commit to providing regular public progress reports on implementation? I might put that to the minister. Minister, given this is whole of government, will the government commit to providing regular public progress reports on the implementation of those recommendations?
The anti-Semitism
Yep, the interim
recommendations.
report. You've accepted all the recommendations?
Well, if it was me, I would, but I shall confirm that with the Attorney-General, because this is her portfolio and I stick to my
Your lane, I know that.
lane.
I know that you do. I'll remember that if I'm ever on that side of the table again. I'm going to remember that.
No, that'll never happen, I'm afraid. Bad luck.
Very, very briefly.
Sorry, it's the Minister for Home Affairs and...
understood. No, understood.
I shall...
not swim in that lane.
I shall not either swim in his lane as well, because he doesn't swim in mine.
Okay.
I used to
I would
employ
never
him.
swim in your lane, Senator Farrell. I would definitely not be swimming in your lane.
Keep out of it.
Exactly. Very quickly, 2 final questions from me. Okay. The interim report recommended that the counter-terrorism coordinator's role be made full-time. The government appointed, I understand, Mr Brendan Dowling to that role with immediate effect. When was exactly the appointment made by whom, and was there a competitive merit process undertaken?
Senator, I'd have to refer you to Home Affairs.
That is Home Affairs, yes. Okay. Just on this one, he is currently the DepSec of Home Affairs. Is his appointment as counter-terrorism coordinator on a substantive or acting basis, and does he retain any of his previous responsibilities?
I would refer you to the Department of Home Affairs, but I believe that in response to the recommendation that the position be made full-time, that is what has happened, and he has been appointed, and they are his responsibilities, and he's commenced in the role.
Excellent. Thank you very much, Chair.
Thank you, Senator Cash. Senator Roberts.
Thank you, Chair. Thank you for appearing again. The Commission found that no further legislative measures would have prevented the Bondi atrocity, but what could have been done by either ASIO or the AFP or New South Wales Police that could have prevented this atrocity?
Thanks, Senator. In relation to the interim report, I'd note that we commenced our second hearing block today, which is expected to run for up to 3 weeks. And the interim report identified that there are a number of issues that needed to be further examined during this next hearing block. And so that's what we're doing at the moment. So I think other than what's in the interim report itself in terms of the recommendations that the Commission has made, I think we need to wait and see what comes out of this hearing block.
So I can understand that. When will we find out? Next interim report?
So if the Commissioner determines that another report is required before the final report, so there's a final report that's due by the 14th of December, but it's open to the Commissioner to issue other recommendations or another report along the way if she considers appropriate to do so. It's, I think, too early to say whether it would be needed to do that, but it's something that can be done.
I can understand your sensitivity about this, and I really can understand it. But a lot of people will be anxious to find out why ASIO, the AFP and the New South Wales Police didn't take action. Will the Commission consider how did one of the terrorists get a clearance to purchase a firearm when the person had been on a watch list with ASIO? Will that be something you consider?
So in this hearing block, the Commission's considering, I guess, term of reference C, which goes to the circumstances in the lead up to the Bondi attack. So there'll be a range of issues considered in that hearing block, some of which will be in public, and then some will have to be held in closed session, either to avoid prejudicing the criminal trial or because it's dealing with classified information.
Thank you. This may be another sensitive question. Were ASIO or the AFP aware that a firearms licence had been issued to one of the terrorists by the New South Wales Weapons Licensing Branch?
I think that really goes to the substance of matters that the Commission might be looking at, so I couldn't answer that.
Yeah. Will the Commission consider what level of surveillance was directed to the murdering terrorists when they were already on ASIO's radar? Will that be something you consider?
Broadly, the factors that the Commission is considering during this hearing block go to to the terrorism threat level, the security environment in the lead up to the attack, the conduct of security, intelligence and law enforcement agencies relevant to the attack. So I think that goes to the issue that you've just raised. It'll also look at the security arrangements for the Hanukkah by the Sea event, how intelligence about individuals known to authority is utilised and is shared between agencies to then inform decisions made by security, intelligence and law enforcement agencies, and including, for example, how individuals are monitored and how decisions in respect of firearms licence applications are made. So yes, those things will be looked at.
So the Commission will consider if any agency did not perform their duties to protect Australians. That's clear.
The Commission will be looking at the conduct of intelligence and law enforcement agencies in relation to those issues I've outlined.
Are you familiar with the letter from the Royal Commission to GAB in the United States?
I don't think so, no.
The Commission sent the social media company GAB in the United States a letter. It was from what the owner of GAB posted on social media. It's not possible to get a clear idea of what your intent was. Can you please explain what that letter was all about? Do you want me to read the letter?
I think I don't have that letter, so I think I would have to
take it
on notice.
Okay, thank you. Your letter included a statement that failure to comply with the notice carried a criminal penalty of 12 months in prison. Is it accurate to threaten a US citizen in the United States with a criminal prosecution under Australian law?
Senator, I don't have that correspondence, so I think it's just best if I take that on notice.
Last question, Chair. GAB have used the United States First Amendment as a defence to such actions in the past, including from our E-Safety Commissioner. So could you tell me why on notice, why take the action when you know the US Constitution precludes you from taking that action?
I'll take that on notice as well once I've seen the correspondence.
Thank you. Thanks, Chair.
Thank you, Senator Roberts, for your efficiency in asking those questions. It means that we are now in a position to release officers from the Royal Commission on Anti-Semitism and Social Cohesion. And on that note, we also adjourn proceedings for today. Thank you very much.